Good afternoon and welcome to my show, Justice Matters. My name is Patty Corrales. Many of you know me. I practice immigration and criminal defense, and I'm here, an attorney here in the area in Monrovia, and I try to help all the Monrovian citizens and residents who may have issues with both criminal and immigration issues. On my show today, we're going to discuss a really interesting and hot topic, and that is citizenship. The right to be a citizen and how you become a U.S. citizen. With the presidential elections gearing up, we've heard much talk about immigration and this thing called the Birthright to Citizenship Act. And we're going to discuss that on my show today. Today, I have the great pleasure of having Paul Cass, who is an attorney in South Pasadena, California. He has offices in Koreatown, and Paul practices immigration defense and does wills and trust and does civil litigation in general. So Paul and I are going to have a very lively discussion about the requirements to become a naturalized U.S. citizen and the issues of citizenship altogether. We have some questions that were sent to my law office about questions relating to how do I become a citizen and certain things about becoming a U.S. citizen. And we're going to address those questions today too. But right now I'm going to let Paul introduce himself to the community. Welcome, Paul, to my show. Thank you so much for coming. If you could introduce yourself to the community, I'd appreciate it.
Thanks for having me. My name is Paul Cass. I've been an attorney for over 30 years, which is a longer time than I would have thought. I don't just do immigration. I've been doing immigration for 20 or so years. I do immigration in part because I myself am an immigrant and a naturalized citizen. I'm originally from Canada. I practice certainly immigration other than deportation, asylum, and such things. I do a fair bit of naturalization and citizenship, which are not necessarily the same thing. I also, as Patty pointed out, do other kinds of law as well, but lately probably more immigration than other areas.
So Paul, let's start out with a very controversial topic.
Yeah.
Let's start out with the issues of naturalization and citizenship. You said they're not necessarily the same thing. Can you tell me what you mean by that?
There are a number of things. For one thing, for example, there are a number of people not born in the United States who may become U.S. citizens because one or both of their parents was a U.S. citizen and met certain requirements. And frequently they come to me for advice as to whether they really are citizens or not. One issue that probably most of your audience is well aware of is that if a family all have lawful permanent resident, also known as green cards, and nowadays one of the parents becomes a U.S. citizen, the children who are under 18 who have green cards will automatically become citizens. That's not naturalization, but it is becoming a citizen.
Right, and those are very
Sure.
different issues.
Right.
And I think you brought up something that is really critical here, and I want to just discuss it a little
Sure.
more and get your thoughts on it. Citizenship, the way we think of it, is people born in the United States, right?
Right.
You're born here, you become a U.S. citizen. Now, some people weren't necessarily born here, but their parents were born here.
Right.
And yet those individuals, those children, could also be automatically
Right.
U.S. citizens, but they don't know about it, right?
That is true.
So they get in trouble somehow, for whatever reasons. The Immigration Customs Enforcement, what we know as ICE, contacts them, detains them, and they, they tell the ICE agent, my mom's a U.S. citizen. My dad's a U.S. citizen.
Right.
What obligations do you believe at that point does the government, like ICE, have to investigate whether or not that individual is automatically a citizen?
I believe that they have a very, very strong obligation to investigate it, because the consequences of removing, or what we call removing, but what most people call deporting, a U.S. citizen are really very serious. They can lead to sanctions against the government, and of course, it's just a bad thing on a policy basis to be deporting U.S. citizens. The problem that I see and I've seen it a number of times, is that, first of all, some of the ICE people don't necessarily do as much investigation as they should. But secondly, even if they do the investigation, there's no database for a lot of these people that proves that they are U.S. citizens. And this is because these children have automatically become U.S. citizens without going through any kind of naturalization process. They've never been entered into the Immigration Services database. Frequently, and many immigration attorneys will tell you this, the parents are advised to apply for passports for the children. And there is a law that says if a valid passport is proof of citizenship. Not everybody follows that law. And although the Department of State, which is a totally different agency, which issues the passports, does have a record that these children are citizens, that information never gets into the Immigration Services database.
It doesn't. And I'm
Yeah,
going to
right.
stop you right here and talk about this because I think it's actually a really important issue. As many of you know, I worked for ICE for almost 18 years. And in my capacity of working with ICE, I mostly handled citizenship or denaturalization related issues. In 2009, John Morton came down with a memo, which was not rescinded, by the way, where it required ICE, should they come into contact in the detention setting with a potential U.S. citizen, ICE had an obligation, including the attorneys who service and who guide ICE agents, to investigate that claim of U.S. citizenship. They had to write what's called a U.S. citizenship memo, okay? And that memo gets addressed to the local chief counsel office, and there's an expert or a person or an attorney there that knows the citizenship laws. Then that memo goes up to headquarters, and if they had any doubt, and the doubt would favor the claim of citizenship than the government, they had to release that individual. That requirement still exists today. It's not rescinded by any chance. But what I find is that there are so many individuals, not a lot, but there are many individuals who are in our detention settings who may have a valid claim to U.S. citizenship because they acquired that claim, citizenship, automatically. Now let's talk about, if we can, in a brief sketch, what are those requirements, Paul? You mentioned one, and that is, and there's, of course, all kinds of facts that may change the analysis. But one is if you, what we call acquisition, where your parents were born, they were U.S. citizens, and you were born in Mexico, for example. If your parents, or particularly your father, or if your father was a U.S. citizen, if they were born in the United States and resided in the United States for a period of time, generally it's 10 years, 10 years here in the United States, 5 of which was after that parent turned, was it 15?
Well, that was actually the old law. The new law is much more liberal. It's basically 5 years after the age, at least 2 of which were after the age of 14. So if the child was born before the parent hit age 16, they're out of luck in that regard. Although the parent could get them a green card, and as soon as they come in with an immigrant visa, which becomes a green card, they're also automatically citizens under what's called the Child Citizenship Act. But in general, yes, the parents had to have had a certain period of time in the United States. The stated policy, and this has been the case certainly since the original act in 1952, was that they wanted to show that the parents had some kind of commitment to the United States before they could pass on their citizenship. And of course, it also depends if the parents were married, because there are different rules for passing on citizenship to children who are born out of wedlock. And of course, I don't want to go too far afield, but it depends on when the child was born. Before 1986, after 1986.
You're right. This area of law, which is acquisition of citizenship, so you acquired citizenship at the time of your birth, okay? Very complex, different factors play into it. But if there is a possibility, go see an immigration lawyer, because you might be a U.S. citizen.
But let's without knowing it.
But let's talk about the other claim for citizenship, and that's when you derive citizenship afterwards. Okay,
Right.
so let's if we can, we know we have the new law, which is the Child Citizenship Act, but under the old law, which is still valid, and many
Right.
people still fall under this under the old law, which is former Section 321 of the INA,
Right.
which is the Immigration Nationality Act. What are the requirements for that?
Well, basically, they are somewhat similar, with one really major exception. Under the old law, it was also the case that that the child had to be under 18 at the time the last required act occurred, that the child was a permanent resident in the United States, a green card holder. The difference was that both parents had to naturalize, and the child would automatically become a U.S. citizen if the second parent to naturalized before age 18, as long as the child was living with the parents who had custody of him, or if the parents were divorced or whatever, was living with the parent who had been granted custody, which can be a real issue.
That issue of the custody
Right.
can actually
Right.
change the outcome of
Absolutely.
whether someone is has derived U.S. citizenship.
Agreed.
I want to ask you one of the questions that I got from one of my potential community members is, what if I'm adopted? What if two U.S. citizens adopted me before I turned 18? Do I automatically become a U.S. citizen?
The law certainly says that there should be no difference between adopted children and naturally born children. The only issue would be, and in fact, in that case, usually the child, if these all things occurred before age 18, then the child would have automatically become a citizen. Nowadays, frequently, the children are, of course, adopted overseas through a very arduous process called, for countries that are signatories to the Hague Convention, including Mexico. But the minute that they enter the United States, if they're under 18, they become citizens, except that they are not given certificates of citizenship. They're not given anything really that says they're citizens. They can apply for a passport, they can get a passport, but they have nothing else that proves they're a citizen. And so I always tell my clients, they don't always follow my advice. I tell them, spend the $600 and change to file for a certificate of citizenship, because that way the child will be in the database, and the citizenship should be easily discovered. And citizenship certificates are forever. Passports are nowadays for 10 years. They have to be constantly renewed. And you can lose a passport. The passport office sometimes becomes very strange in issuing passports. Like, for example, if you fall behind on your child support to a certain amount, if you commit certain types of crimes, you may not be able to get a passport.
They will not give you
Right.
a U.S. passport. So that's very true. So when if you believe that you may have a question of whether or not you're a citizen,
Sure.
we recommend that you talk to a licensed attorney who
Sure.
can speak about these matters, because they
Right.
truly can affect you in the long run.
There is a huge difference between being a permanent resident and being a citizen.
And that's absolutely true, Paul. And that's something you touched upon that I just really want to focus on, and that is the difference between becoming a lawful permanent resident and being a U.S. citizen in this country. With all the political, hogwash that we've been hearing lately,
I second that.
I think it is prudent, if you are a lawful permanent resident and eligible to become a U.S. citizen by naturalization, through naturalization, you should do that. Because frankly, lawful permanent residents, while I don't want to scare our community, their rights could soon be eroding little by little. And so
Yes.
it's really important, if you are eligible to become a naturalized citizen, to take those steps to become one. And now we're going to really talk about
Sure.
what are those requirements for naturalization. We know that the basic requirements are the basic ones. I'm going to talk about the basic
Sure.
ones. I'm going to have you talk to us about all the, in between requirements.
Sure.
You have to be a lawful permanent resident for a period of 5 years. You have to show that you're a person of good moral character. from the time 5 years prior to filing that application for citizenship, which now costs $680, up until the time you take the oath of allegiance and swear allegiance to this great country. You also have to have been residing here or in the district where you apply for a certain period of time, correct?
Right, that's called continuous residence.
Continuous residence. And then, of course, you have to swear allegiance to this country and give up, any kind of allegiance that you have to any other countries or any other foreign nations or foreign sovereignties. Let's talk about some of those requirements,
Sure.
Paul. Let's talk about the first one. Do you have to wait 5 years? Are there some exceptions? And can you talk about the exceptions?
Yeah. Well, first of all, although it says 5 years, the law says that you can actually apply 3 months before the 5 years if you have met all the other requirements. The theory, I think, is that by the time you have the interview, you'll have the 5 years. So it's 4 years, 9 months. Unless you are married to a U.S. citizen and have been married to that U.S. citizen for at least the past 3 years, and the U.S. citizen has been a citizen for at least the past 3 years, then it's a 3-year track rather than a 5-year track, and 2 years, 9 months rather than 3 years.
What about the military?
Military actually is much faster. You can do it really after, I believe, 1 year.
1 year.
Right. And which is certainly, and by the way, some people join the military just so that they can get that naturalization quickly and can then sponsor various family members, such as spouses, parents, children, even relatives overseas.
Let's talk about the let's talk about the naturalization requirement of good moral character, because I think that's the big one.
I agree.
Of all the requirements, good moral character is the big one.
Well, I would say there's another big one,
Okay.
which is that you have to continuously reside in the United States during what's called the statutory period, which is either 5 years or 3 years. And although you're not chained to the United States for every day of that time, you can't be out for more than half of that time, and you really should not be out for more than 6 months at any one time. And a lot of people try to play this, they try to shave the days and so forth. I will say that, and I'm sure you go to a lot of naturalization interviews, the officer who's doing the examination will have a printout from U.S. Visit, which will say exactly how many times you entered, how many times you left, how many days they calculate you were out. So you really have to be very careful about that. But yes, I agree, good moral character is a major issue.
It is a major issue, but you know what? You just touched on something that I want to speak about a little further. One of the other issues, as you mentioned, is continuous residence.
Right.
Okay, I had a client who I was applying for naturalization for him, and when I asked him, okay, how many times? The question is, how many trips have you taken outside the United States in the last 5 years, right? How many days have you been out of the United States in the last 5 years? How many trips in total, right?
Right.
So my client, a 75-year-old man, really can't remember. Okay, and in his passport, there wasn't any significant stamps because as a lawful permanent resident, they just normally show their card and they're let in.
Right.
So in those situations when someone really doesn't recall the exact dates that they've, left and come back, it's really difficult. But you're absolutely correct that you don't think that immigration doesn't have this information,
Right.
because they inevitably have this printout from U.S. Visits, which is a database that tracks people's entries and into the United States. So you really have to give the best information you
Absolutely.
could possibly can.
Right.
But Paul, let's talk about something in
Sure.
that regard. As a lawful permanent resident, you have a right to come in and out. And
Correct.
the question always specifically says, any trips outside the United States more than 24 hours,
Right.
right?
Right.
What pisses me off, to be frank, is that some of our clients, at least some of my clients, would go to Mexico and come back within the 24 hours. So those trips don't count.
I agree.
Yet, USCIS has printout of those trips. And
Sure.
because the client hasn't been forthright in marking down every single exit, we have now an issue of misrepresentation, which I don't think it's a misrepresentation.
I would fight that. And as a matter of fact, the Immigration Naturalization, and by the way, the Immigration Naturalization website is really good on citizenship. They have all kinds of materials to help people. But they have issued what's called a policy manual. And they also have a guide to naturalization. And in both of those cases, they say you do not count part of any day which you spent partly in the United States. So the day you came back shouldn't be counted, and the day you left shouldn't be counted.
Correct.
And if it's a one-day trip, as far as I'm concerned, they do not have any absence of 1 day or more.
Then why are the officers insisting on that? And I have no idea, but that is one of the issues that I see, and I'm like, it drives me mad.
I agree.
But the point of that discussion is to share with all of you that do your best and try to remember all your departures from the United States that are more than 24 hours. Because it's really critical that you give the best information out, because at the time of your interview, they're going to have a printout of all your exits, of all your entries.
Agreed.
Let's talk about the good moral character. What does that mean? Well, tell our audience what we're talking about.
Well, good moral character is not really defined. It's generally, what are the community standards for a person of generically defined good moral character. I think we're pretty clear that murder probably is not good moral character. And in fact, if you've committed murder, you can never show good moral character, even if it was 30 years ago. Certain types of felonies that are called aggravated felonies, which the government deems to be particularly serious, and are defined in the Immigration Nationality Act in Section 101, are things that you can never recover from for purposes of naturalization. But then there are other kinds. There are, as you know, generally there are things called felonies, which can be variously defined, but are usually set by law, usually carry a sentence of more than 6 months, but there are times when that's not the case. There are things called misdemeanors, which are generally would carry a maximum sentence of less than 6 months. And there are even infractions like speeding tickets and things like that. Generally speaking, the government takes the position, and the regulations say that there are different grades of crime. Some of them are what are called crimes involving moral turpitude. I think moral turpitude is something that so offends the moral standards of the community that they are to be taken very seriously. And those can include, armed robbery, arson, although that's also an aggravated felony.
Domestic violence.
Domestic violence, which is another can of worms, which we can't, complete the discussion of here. Fraud, certain types of fraud, embezzlement, and so forth.
And also, Paul, let's not forget one of the things that we see often in these naturalization denials is misrepresentations.
Yes, material misrepresentations.
Material, thank you. Material misrepresentations or false testimony.
Right.
So explain those just a bit if you can.
Well, we all sort of know what a misrepresentation is. Misrepresentation is essentially a lie, which can include not telling the whole truth, telling a partial truth, because what we call omissions, if they are what are called material, can also be significant. What is the definition of material? Well, if by not being forthcoming about that fact, you foreclosed a line of questioning that, if it had been followed, could have resulted in a negative result for you. So, for example, we've had this debate about birther tourism.
Right.
And the Immigration Service frequently, but not always, takes the position that if you were really coming to the United States as a tourist, intending to leave, but you were also planning on giving birth to a U.S. citizen baby, what is improperly called an anchor baby, but you didn't tell the consulate that, the consulate gave you a visa, then they frequently take the position that you have committed a material misrepresentation. I disagree, because even if you told them, I want to have a baby in addition to shopping on Rodeo Drive, they should not, on that basis, deny a visa. So.
But
Yeah.
I think you gave a good
Right.
example. So, for example, there's many individuals who've come to this country
Right.
to visit, but for reasons out of their control,
Sure.
they stay, right?
Yeah.
So immigration could take that to mean that they actually didn't intend to come here to visit. They actually intended to come here to stay and live and grow old here. And that was a misrepresentation on their visa application. So these are things that could actually affect someone's
Yes.
ability to become a naturalized citizen.
Yes.
So if you have situations like this, it's always good to see an immigration attorney to
Agreed.
see how you can overcome these issues, or how can you argue
Right.
against the finding that it was a material misrepresentation. There's another question that I got from one of our callers, and that is, what if I accidentally voted and I didn't know that I couldn't? How does that come into play, if you will, when applying for naturalization?
For one thing, of course, it actually, to some extent, depends on the state law. Some state laws allow voter are vaguer on what constitutes a right to voter registration than others. There's a case that one of our colleagues handled in the Ninth Circuit of somebody who had registered to vote in Hawaii, which has a different state law for voter registration than, for example, California. But the bottom line is that generally, in order to vote, you have to be a U.S. citizen. If you are registering to vote, you are essentially telling the government that you are a U.S. citizen when you are not.
Yeah, but Paul, come
Yeah.
on. We have so many young kids who've been in this country forever and a
Right.
day. They grew up thinking they were U.S. citizens
Right.
because they grew up here, right?
Right.
They went to school here, they went to high school here. Hey, and they came to find out, I'm not a U.S. citizen, unbeknownst to them. So they
Right.
sign up to register to vote because they want to be involved in our country. They want to be involved in our community.
I agree.
They didn't know. How, when they find out, is that non-intentional act going to be held against them?
Well, they are deemed to have intentionally registered to vote. However, there are a number of memos which provide for some kind of clemency, as it were, especially if the person was too young to really form the intention to defraud or to do a false claim of citizenship. But yes, this is a real tragic consequence that happens when parents are not forthcoming with their children about their actual nationality. It may even be that, unfortunately, the parents may actually believe their children are U.S. citizens because they have consulted non-attorneys, frequently known as notarios, who have fed them a bill of goods, that they have regularized their status when they haven't.
It is an unfortunate situation.
Right.
Now, we were talking about different issues in relationship to this good moral character
Right.
requirement to become a naturalized citizen. Now, one of the questions that I got from a individual who faxed into questions
Sure.
for this show is, what if I'm on probation? I've been convicted of a DUI, but I'm on probation. Now,
Right.
as practitioners, we know that a DUI, though taken very seriously in this country, is not a crime involving moral turpitude.
Right.
But if they're on probation, I'm telling this person who wrote in, you cannot become a naturalized citizen until
Absolutely.
that probation is terminated.
Absolutely,
correct?
that's in the regulations specifically.
It's not only in the regulations, but it's also a question of, what if you violate your probation? Then you can go to jail for that. So there's always issues related to the underlying crime. So until you're finished and completely through with your probation, and depending on the nature of the crime, you cannot apply for naturalization. Would you agree?
I certainly would agree.
Now, another caller called in and said, okay, I became a lawful permanent, another writer came in. I became a lawful permanent resident through my wife, and that's how I got my lawful permanent residency. But now I want to become a U.S. citizen. However, I'm not married to that same wife. Can I become a naturalized citizen through 3 years instead of 5?
Absolutely, 100% no.
Why is that, Paul?
Because the 3-year requirement, as I think I previously mentioned, requires that you not only have been married to a U.S. citizen for the entire 3-year statutory period, and that the person was a U.S. citizen during that time, and that you were married essentially and living together. And in cases where you are applying on the 3-year basis, the examiner will ask for evidence that you are still living together, and they will frequently will ask for evidence for that entire 3-year period, such as joint tax returns and things like that.
But if he has 5 years of being a lawful permanent resident, then that person can
Agreed.
apply for
Yes, but not on the 3-year basis.
Not on the
Yeah.
3-year. Okay. Another question we got was, I just committed a crime. That's not good. All right. And the crime that I committed was joyriding. Can I still become a naturalized citizen?
The answer is, I can't give a definitive answer. Joyriding, in general, yes, it is a crime. It's generally not considered a crime involving moral turpitude. If it's a single crime and it's the only crime the person has been arrested for, it should not bar the person from naturalization. Although, if the crime happens so soon before filing the N-400, by the time of the interview, there is some discretion on the interviewer's part. They may want to see where the case goes. But in generally, a joyriding conviction of itself shouldn't bar a person from naturalizing.
We can talk about every single crime,
Sure,
because every
sure.
single crime is going to affect
Right.
an individual,
Right.
and it's really important that you talk to a licensed immigration attorney. And as Paul said, don't go to notarios. Don't go to individuals who are consultants, because they really don't understand the law. Because the law is not just the law in terms of the statute, it's also how courts have interpreted the law.
Sure.
So it's really important to talk to someone. But I'm going to talk to, Paul and I are going to talk about certain types of cases that we generally see. So I just had an individual who, fortunately for him, naturalized, which is hooray, and I expect him to vote, where he had a history of DUIs, like 3 or 4 in the early 70s, nothing since that. And he was a lawful permanent resident for years, but he was so afraid to apply.
Sure.
In those types of situations, if you're an individual who's been a lawful permanent resident for 20 plus years or 30 plus years, and you've never thought you could become a U.S. citizen because of very old crimes, some of those old crimes may not affect you at all, but some of those old crimes can still put you in danger to be placed in proceedings to be deported. And that's the critical problem in these situations.
And that's why you really have to analyze the crimes to determine, A, whether they're crimes involving moral turpitude or not, and what their effect would be on your ability to naturalize. Because, as you well know, the regulations say that although you have to show good moral character for the required statutory period, which is either 5 or 3 years or even 1 year for military, if you have crimes that are outside the statutory period that the examiner believes may tend to reflect on the person's good moral character within the statutory period, or which show a lack of good moral character, the examiner can reach back outside the statutory period to consider those crimes. A string of DUIs, while unfortunate, and in such cases, I might add, I do ask the person to provide evidence of rehabilitation and letters and things like that, and that they completed all their probations and so forth, went to the classes if required. If they're that old, should not be an issue. There is a very little used provision of the immigration law that a person who is deemed to be an habitual drunkard cannot show good moral character. I'm not really sure what a habitual drunkard is. I believe the only case I've ever seen is a person who's a chronic alcoholic. If a person's been had no DUIs for the last 17 years, I think it's going to be hard to show they're a chronic, an habitual drunkard.
Right, and I think the point is, I think it's very important to tell people out there in our community that, okay, so you committed crimes way back when, okay, old crimes, and then you rehabilitated. You started to go back to church, go back to your family. You started investing in this community, and you've had nothing since. And now someone's told you, well, you're eligible to become a U.S. citizen. You should apply. You should apply to become a naturalized citizen. Don't do so without talking to an immigration attorney, because even though those crimes are so old, some of those crimes, like Paul just said, depending on the type of crime,
Agreed.
can still
Right.
affect you so many years later, and not just to deny your citizenship application, but also to put you in proceedings where you could be now placed in deportation proceedings
Right.
after 20 years.
That's
so
true.
it's really critical that if you want to try and become a naturalized U.S. citizen, so many factors play into it
Sure.
that you really have to see an immigration attorney.
But one thing I did want to mention that I do get a lot is, I've really reformed. But back in the day when I was 14, 15, 16, 17, I was kind of a wild person. And I had a lot of run-ins with the law. I was in juvenile detention for a while. I was adjudicated as a juvenile delinquent. I have a whole bunch of stuff. And by the way, that shows up on my FBI rap sheet because I was printed. Is that going to stop me? And in general, my opinion is no, because it's not a juvenile delinquency, or a juvenile adjudication, whatever that is not considered a crime. And therefore, whatever they got you for, with very few exceptions, is not a criminal conviction. But that's something that stops a lot of people as well.
That's a very good point. If you back in your youth
Right.
have had to go to a boys' home or
Right.
or anything like that, and you were adjudicated juvenile delinquent, depending on whether or not they sentenced you as a
Exactly, right.
delinquent, as a juvenile, then those juvenile adjudications do not count.
Right.
And now we have some case law that even says that specifically.
Absolutely.
And we even have now the governor. Has he signed it, or is he intending to sign it?
I think it's on his desk.
It's on his
last I heard.
It's
Right.
on his desk to sign a law that would actually make those juvenile adjudications absolutely clear that law enforcement doesn't get a copy of that. Correct?
Yes, that is right, and they're absolutely sealed, because sometimes juvenile determinations are not sealed.
That's true.
And but also even if they're sealed, frequently prints are taken and sent to the FBI as a matter of course, and maybe the California Department of Justice. So even though they're from something that happened at age 16 and the person was never tried as an adult, there is something in the FBI record that says they were they were at least taken into custody. And so the question then is, do you have to address that? If they say, have you ever been arrested, et cetera, and you answer no because everything that happened to you was as a juvenile, are you at risk of, and I believe it is not a criminal conviction, are you at risk of being denied naturalization because you were not fully forthcoming?
Because you gave false testimony.
Because you gave false testimony.
Because they say that you
Right.
materially misrepresented
Right.
his
Right.
arrest record. I would argue absolutely not.
I would argue that as well, but my general feeling, depending on what the record is, and depending on, and I usually have them get their FBI record before I even tell them what to do. I will frequently put in just a little argument as to why, even if that were possibly something that would affect naturalization, if the person had been treated as an adult, it should not be considered.
Absolutely. So many issues surrounding the ability to become a naturalized citizen in this country. However, it's so important. The political scenario is changing. And if you've become a naturalized U.S. citizen, you went through the whole process. You've paid an immigration lawyer. You suffered through the anxiety of whether your application is going to be approved or not.
Right.
Now is the time to vote. Now is the time to have your voice heard. Because, well, now we're going to get into a very controversial issue. We've heard in the Republican Party, we've had Donald Trump, we've had
Rand Paul.
We've had Senator Cruz discuss this Birthright to Citizenship Act and how it should be passed, that we should change the U.S. Constitution to make it absolutely not a right to be a U.S. citizen in this country simply because you're born here. And, Paul, there's been some there's been a lot of anti-immigrant fervor lately, and in particular when you hear in the news a hotel had a whole bunch of women from China, and they were housed at this hotel so they simply can give birth to their children here. Talk to me about your your position on this Birthright to Citizenship Act, because I certainly have one, and I say no.
Right. Well, we have had discussions on this, you and I actually share your opinion that what is commonly referred to as birther tourism, excuse me, is not a good thing, because not because it invokes birthright citizenship, but because frequently the children are taken back to the parents' home country soon after birth. They have a U.S. passport. They grow up frequently without learning the language, without being schooled to have what we consider to be basic U.S. Citizenship values instilled in them. They don't have any particular loyalty to the United States. Not that a citizen is necessarily required in every case to hew to the party line, but they have no particular connection to the United States. And at some point, theoretically, they can bring other relatives in after they reach age 21. So, I am concerned with a growing group of people who are U.S. citizens who really are not part of the cultural fabric of the country. So yes, I'm concerned about that. I am not as concerned about people who are actually born here and wind up living here for their lives. I have no doubt that the 14th Amendment of the Constitution says that they are U.S. citizens. I know that there was an argument that I think Donald Trump has made it, maybe there's some renegade law professor somewhere who has said, well, yeah, but if they are born to people who are undocumented, then they should not be considered U.S. citizens, because the 14th Amendment of the Constitution says all persons born in the United States or its territories and subject to the jurisdiction thereof are U.S. citizens. And by the way, that's the first time that citizenship was defined. It was never really defined before. But and so the theory is, if the parents are not if the parents are not documented, then they're not really subject to the jurisdiction of the United States. I think that's disastrous, because if they're not subject to the jurisdiction of the United States, you can't arrest them, you can't discipline, you can't kick them out, really, because they're not subject to your jurisdiction.
Correct.
And there is some case law anyway that says yes, undocumented parents are subject to the I think it's a ridiculous argument.
It is a ridiculous argument, but I think more than that. I think this notion of a birthright to citizenship, to change our Constitution, it's never going to be done. It's not going to happen.
As a practical matter, it's almost impossible.
Right, but to do that for the purpose of being anti-immigrant, it just goes against the entire notion of what this country is built on. I mean, I want to ask, Donald Trump. I want to ask Senator Cruz. I want to ask all these proponents.
Right.
You have no immigration history in your family, because you do.
Well, we know Ted Cruz does.
Yes, Ted Cruz does. We have Senator Rubio who does.
Sure.
We've got all of them. This is not the time to shout or to scream anti-immigration. I mean, most of the population here, or all of the population here, have a right, not a right necessarily, but have contributed to this country. Now, I don't think that it's right to just say only those who merit to become a U.S. citizen should become a U.S. citizen, which is what they're kind of proposing. Now,
because for one thing, that's a highly subjective and I think really unfair test. And what particularly perturbs me is that would changing the Constitution, or some people believe that you can just reinterpret the Constitution, and if you get the right composition of the Supreme Court, who knows? But would that retroactively affect? Would people suddenly become denationalized, denaturalized, who have always been U.S. citizens? Would people on whom they conferred permanent resident or citizenship by virtue of their citizenship, suddenly be denaturalized. How many generations back would you go? Even though the Constitution says you can't have ex post facto laws.
But Paul,
yeah.
listen,
Yeah.
in this country, we're one of few countries who
Yes.
automatically give citizenship to individuals who are born here. There are other countries who don't.
Sure.
If I go and I move to Mexico, I'm not or if I go to move to
True.
Mexico and I have a child, my child is not automatically a Mexican citizen. So why isn't it that we want to make it more difficult, more challenging to become a U.S. citizen? U.S. citizenship is the greatest right we can bestow on an individual. Why don't we want to say to them, okay, you got to earn it? Why do we want to just give it away? Because that's kind of the argument there, right?
Well,
That's actually the argument.
Traditionally, in countries where you have to earn citizenship, frequently they enact laws that make it almost impossible to earn the citizenship. I think of Switzerland, which will allow people to become permanent residents and citizens if they continuously live there for a certain period. So they very cleverly give them visas that are for just a little bit less, kick them out, let them back in so they can never get the continuous residence. That's just one example. I see that's one reason. Number two, as you know, there are two basic types of citizenship laws around the world. One of them is what we call jus soli, which is basically the law of the territory, of the land. So a person who's born there becomes a citizen. And the other is jus sanguinis, which is law of the blood based on your relatives. I find and the United States, of course, is one of the few countries that has both. But I do find that just the law of the blood can be misinterpreted to issues of what they so-called racial purity and so forth, which we as Americans really don't want.
But that's what Trump is proposing.
Yes, he is.
He's proposing that.
And but it's very un-American.
Very un-American, and it takes us back to days that we don't even want to talk about.
Well, right. I mean, one of the arguments that these people make is, well, you know, the 14th Amendment was enacted after the Civil War because originally the Constitution had provided that African Americans, blacks, whatever they were called at that time, were only 3/5 of a man and could never be citizens. The Dred Scott case, of course, which was just before the Civil War, had the same thing, and therefore 14th Amendment was enacted. But people, the 14th Amendment, if you look at the history of it, basically looked at traditional English law that had been there for centuries and decided that the law of birthright was appropriate. And by the way, they carved out subject to the jurisdiction because they were aware that children of diplomats, for example, who have diplomatic immunity are never subject to the jurisdiction of the United States. So trying to narrow the 14th Amendment to just African Americans who are born in the United States is, in my opinion, a losing argument.
Well, it's ludicrous. But I think more than anything, behind this whole, if you will, propaganda is it's not so much. I don't see it as much a legal issue as it is an anti-immigrant issue. I mean, they're really trying to be vocal about all the unlawful individuals who are here not documented, right? And so that's where I think that is going to. I mean, Trump keeps bringing up what happened. It's an unfortunate incident, what happened in San Francisco. Look at all these immigrants who are here who are criminals. They're bad. Get rid of them. Let's send them back. Okay, I promise you, United States, if you make me the president, the next day I'm deporting the 11 million undocumented individuals. And I want to say, Mr. Trump, there's something called the Constitution and due process. But more importantly, is this: there are ways to enforce our laws justly and in a balanced way. So if we have a U.S. citizen who should have never become a U.S. citizen by naturalization, the government has a right to take that citizenship away. There are ways to enforce the individual, to enforce our laws to deport or to remove individuals here who pose a threat to our community. but 11 million people do not, undocumented people, do not pose
Right.
a threat to this country.
No, and you know, I mean, he of course conveniently neglects to point out all of the native-born Americans who are of what we call white Anglo-Saxon
Saxon.
background, who also commit these kind of crimes because they're let go for reasons of jail overcrowding or otherwise. So, I mean, to concentrate on the really comparatively few immigrants, undocumented or documented immigrants who commit such crimes, to tar an entire community with that brush is ridiculous. I would just also add that I believe that if Donald Trump, Rand Paul, Marco Rubio believed that these people would wind up voting for their party, they would not be so eager to change the 14th Amendment. What they're worried about is that there would be a serious demographic shift in the country, which will not be to their advantage.
Of course
and that's not a basis for doing something so serious as trying to amend a constitution.
That is,
Right.
it's a very serious thing to try to do that. Done, when was it last done for? Prohibition, right?
Yes. Well, and of course the
voting.
and of course the amendment. Yes, that was the last repeal. That was the last repeal of a constitutional amendment. But subsequent to that, of course, there was the amendment that allowed 18-year-olds to vote. So,
yes.
you know, yeah.
Well, we could go on and
Right.
on with this discussion,
Sure.
but I want to thank everybody for joining us today. I want to tell the community out there that if you were just recently naturalized and were able to now stand and as a U.S. citizen, go out and vote, have your voice heard. You are in the same position that many other people are
Sure.
in now. So vote and vote justly, and don't vote because of politics or scare tactics. Vote because it is the right thing to do. That person represents those right issues, those right ideas.
I consider it a right and a duty. I mean, I believe that is one of the duties of. That's one of the more pleasant duties, including there are also unpleasant duties like serving on a jury. But you know, I consider that an absolute duty. It's not the only reason to become a citizen, but
Yeah, it's a right and a duty,
Right.
as Paul said. If anybody is contemplating applying to become a naturalized citizen or has questions as to whether they are a U.S. citizen at this point, please contact either myself or Paul, and I'm going to let Paul give his contact information. So if people need to contact you, Paul, where can they reach you?
well, they can. My website is down. It'll be up again, which is www.pauldcast.com, and my email is pdcesq@gmail.com.
And is there a number they can contact you?
Yes, sure. 213-487-1595. Unfortunately, I will tell you, although I do understand Spanish fairly well, and I read it really pretty well, I don't really speak it. So I do have some issues giving consultations in Spanish.
But if people
Right.
will need to talk to Paul, you can reach him at those at that contact information. If you have any further questions or have any other suggestions, or you want to have a consultation with me, you can contact me at Patricia.M.Corrales@gmail.com, or please feel free to contact my office at 626-791-1434. Thank you again for joining us, and have a wonderful afternoon.
And
Thank
thanks
you,
for
Paul,
having me.
so much for coming.